This presentation, we will be looking through what ethic means in a legal sense, why it exists, and how it may have been breached and or applied in this case. We will examine and discuss Boris's conduct in paragraph 6 to 16 in light of the relevant provisions of the CPA. The CPA is the Civil Procedure Act 2010, imposes duties on practitioner when undertaking civil litigations. The legislation that sets this out is overarching obligations. The overarching obligations are a set of rules for the way in which parties to litigation must conduct themselves. They are contained in section 16 to 26 of the Civil Procedure Act 2010. Under Section 41 of the Civil Procedure Act, it is necessary at the outset of the proceeding for each party to sign a certificate stating that they have read and understood the overarching obligations contained in Section 16 to 26 of the CPA. In point 15, the client, Teresa, signs the certificate. She was advised that it is a formality for court proceedings. Client read it and confirmed the facts as pleaded to be correct and signed it. Do note that the certificate must be signed by party personally, not by the party's lawyer. Overarching obligations. As a lawyer, Boris must ensure Section 17, which is act honestly. He advised Teresa of cost verbally and also in the letter. Point 6, 8, 9, 16. However, not providing a bank account details and taking cash could have been seen as dishonesty. He should have informed client to pay retainer at bank account and or provide receipts. But the main overarching obligation here is Section 18. Which basically is the proper basis. Under this section, obligation not to make a claim or response to a claim in the proceeding that is frivolous, vexatious, and abuse of process, or does not have a proper basis on the factuals and legal materials available at the time, which is also in Section 42 CPA 2010. Other areas of compliance for Boris was Section 25. There was no delay in Boris's actions to act for Teresa, and necessary steps to gain a CPA certificate was initiated within reasonable time. Point 16 and 11. Giving the client 7 days notice to respond was in compliance to the above section, and also for Section 16 to further the administration of justice. However, was it sufficient to initiate proceedings is what is of question. Although Boris was compliant to Section 12 to 13 and he acted upon the client's instructions in this manner, my concern is mainly, and this is where I'll bring my presentation to a conclusion, is that Teresa received very minimum advice in this matter, and she persisted with instructions. In such cases where a client persists with instructions despite advice, it may be helpful to refer to this provision of the CPA. Section 13 of the Act provides that the overarching obligations do not override a duty of a practitioner to a client to the extent both can operate consistently. Boris and Teresa did meet quite often, regularly, and was quite consistent in the dealings. Despite this, in the case of any inconsistency between any overarching obligations and duties, then the overarching obligations would prevail. Further, practitioner is not required to comply with any instructions or wish of the client that is inconsistent with the overarching obligations. And finally, in circumstances where a client insists on a course of action that would contravene an overarching obligation, it may be necessary for a practitioner to cease to act for the client. Thank you.